Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm the Moorish Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. Moorish Empire, traveler on the land, bitch snitch, Moorish Empire, God dang, you're right, traveler on the land, bitch snitch. The late evening U.S. people.
What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Hey, good morning, good afternoon, good evening, good night, everybody, whoever you are, wherever you are, whatever you're doing, whoever you're doing it with. I'm just glad you're doing it here with me. And wow, it looks like our aspect ratio is all messed up here today. Isn't that awesome? I'll just have to deal with that at some point in the future. Can't be bothered with it right now. I know how to fix it, but I just don't want to. I don't want to break the stride. I'll readjust the aspect ratio here in a bit. But anyway, I'm glad you're all here because today is the day that was supposed to be yesterday. Yesterday, as you know, we were supposed to be watching the Sarah Boone status hearing, which is the motion hearing, the hearing on all these motions we read last week with her wanting some money for this and money for that, standby counsel, new lawyer, and all that other fun stuff. We were supposed to be doing that yesterday, but either they're not showing these live and we just have to wait until after to get the video, or because of the Hurricane Debbie, they decided they weren't going to do it live because probably nobody wanted to go out. I don't know which of those reasons is the reason, but for whatever reason, we could not watch it live yesterday. So instead of that, we did some readings. We began our reading of the 58-page love letter she sent to the judge, full of all kinds of Sarah Boone-ish stuff. We got okay, and it's going to be a few parts before we get through all of it, and we will get through all of it as time allows. But there were some people that were upset. If you go back at yesterday's video and you look at the comment section, there's one comment saying, I watched for 15 minutes and there was no letter. I'm out. Well, if you watched for 15 minutes, you also saw that we were doing this. We were expecting to be watching a live We were expecting to be watching a live hearing, but it wasn't happening, and we were trying to find out why. We had our very own Jules that's here in chat on the telephone with the court for 20 minutes before the show began. We had mods looking for every possible available source of live video of the hearing. We were doing all of that. So if you really did see the first 15 minutes, then you would know that that's what was happening, and you should have a little more patience. And also, for those of you watching on replay and they're thinking, oh, you just do too much talking before you get down to the meat of it. We do that for a reason. We have a longish introduction, and then we talk a little bit so that it allows time for the video to get out there, for people to get notifications, people to stop doing whatever it is they're doing and get here into the show. We do it for a reason. So we do 5, 6, 7 minutes. Sometimes it can be up to 17 or 20 minutes, depending on what the circumstances are. But just fast forward through it. That's all you got to do. Just slide it across, and you'll be able to see when I stop talking and we get into whatever it is we want to do. Don't be so sensitive, people. We're doing the best we can. All right, but here we are today. It is the hearing. As I said, it was supposed to be yesterday. We're doing it today, and let's take care of some of the housekeeping stuff real quick. Here we have our like and subscribe poll. Currently, we've got 230 people and 122 likes. I expect there to be a lot more people coming in as we continue along, as we progress through this. Hopefully there will be anyway. But make sure that you hit that like button. Make sure you hit the subscribe button if you haven't already done so you don't miss any more of these. You don't want to miss it. You want to be right here for all of your Sarah Boone needs, your future Courtney Clenny needs. We got a Karen Reed hearing coming up at the end of the week. We've got a YNW Melly's retrial scheduled for sometime next year. We've got a lot of stuff going, and there's always other things going along here. You do not want to miss it, so hit that subscribe button, hit the notification button, and if you are subscribed, as always, double check just to make sure you are still subscribed, because YouTube is asshole, and they just delete people occasionally. And once you've done those two very important things, come over and take our like and subscribe poll. 20 of you have cheated. I wouldn't have it any other way. It just wouldn't be a like and subscribe poll if there weren't a big bunch of cheaters that take the poll without liking and subscribing. Well, today's like and subscribe poll is Sarah Boone. She's got an airtight defense. Or Sarah Boone, she's got baggage, but I can fix her. Sarah Boone will have her case zipped up tight. And just stop it. We'll check back in an hour or so and see what the preliminary results are of our like and subscribe poll, which does nothing but remind you to like and subscribe. And we've already got a couple of super chats, or just a super chat. We already have a super chat in the link here, so we will read that here. But just briefly, super chats are optional, not required to engage with the host, but because they are bright and fanciful little colors, and because it's you parting with your hard-earned cash, I guarantee you anything you say in the super chats will be reviewed and read and addressed as we go along. Otherwise, I'll try to pay attention to chat as much as I can and pull up some things I think are interesting. But if you got something on your mind, if you got something to say, and if you just really have to have it out there, then please, by all means, super chat, and I guarantee it will be taken care of. And as always, we have our first achievement to unlock. We have the goal. We have to get to the goal. The goal is to unleash the emotional support potato pig dog cam with the however many of the dogs are still remaining in the room at that point in time. We didn't hit it yesterday, so we have to reset our dogometer back to 0 days. Let's see if we can get the streak back up and going again. Let's see if we can get to that goal and unlock that achievement. And with that, I think we got everything out of the way. Beginning is putting us on our way to unleashing the emotional support potato pig dog cam is Rick Nikita. Rick Nikita, the $5 super chat. Thank you very much. Today was the day that was supposed to be yesterday. My brain now hurts. Well, don't worry about it. Just pretend that today is today and not yesterday. Flux says, Jeff. Hey, everybody. All right, that's it. 9:50, 9:51, 9:52. We got to all the stuff we need to do in 10 minutes. So this is a rather lengthy trial as well. It's an hour and 47 minutes. So we need to shut up and get on with it. All right, people, let's do it. And again, hey, wow, that was weird. My aspect ratio fixed itself. That was really weird. Did y'all see that? Did that weird little thing come through there? That was odd. Wonder what that was all about. I touched nothing. All right. Ghost in the machine, kids. Ghost in the machine. Huh. All right. I'm not even going to try to figure it out. Let's get on with it. Present screen. Sarah Boone. Bang. And I'm going to make myself as big as I can because I'm one handsome mother effer, and I would not want to deprive any of you ladies or dudes, if that's what you're into, from gazing upon this handsome visage as we move forward through the day. All right. If there's a reason to, I'll move myself and then smallen myself. But for now, let's just go with it. Ladies and gentlemen, I present you yesterday, I guess it would be the 5th. The 5th of August, 2024, Sarah Boone, pro se, she's representing herself, motion/status hearing. Let's go. And I listened to the first couple of minutes, and I've seen the court they've split their audio. So like the judge is going to be in your left ear and everything else is going to be in your right ear. Pretend it's like the early or the mid 1970s when hi-fi stereo was a new thing and you had all the bands playing with the right and left speakers going back and forth. Pretend it's that day. All right.
Case number 2020 CF2603, the state of Florida versus Sarah Boone, state.
Dave Ketchstrom, behalf of the state. William Jake for the state.
Ms. Boone, raise your right hand to be sworn, please. Please swear to affirm that the testimony you should give shall be the truth, the whole truth, and nothing but truth, so help you God. Yes.
Ma'am, good morning. Could you please state your full name and date of birth for the record for me?
Sarah Boone, 101077.
I do see that we have a representative from JACS that's appearing virtually. Sir, can I get your appearance for the record as well?
Yes, Your Honor. Christian Lake with the Justice.
JACS is the justice people. I actually cut him off in the middle of saying that, but they're the prosecution side of things. Basically, they're not the prosecutor, but they're the government side. They're the ones that are in charge of the money and what have you. And I think it's interesting. I love the judge's voice and the judge's cadence because he's like, all right, here we are. This is going to be another day in court, and I'm just going to treat it like everything else. He actually sounds happy to be there. Like, I know there's going to be some intercoursery afoot, and I don't give an intercourse. I'm just going to go straight on to the hearing as if there was nothing unusual going on in this courtroom. No, nothing to see here.
Administrative commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state.
All right, so if you remember, she gave us 5 separate motions. So we're going to go through 5 motions and see what the state's reply is and how the judge decides to handle it. Of course, we are going to get to hear from Sarah. She's going to be able to give her side of the arguments as well.
From yourself and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed costs to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense in trial dated July 18, 24, received July 29, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18, 2024 and received July 29, 2024. I have reviewed all of those motions. All 3 motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As to the depositions, the date are to be determined, and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is if
That looks shockingly. Let's try that again. That looks shockingly like me when I weighed 100 pounds more than I normally do. Well, than I do now, not when I normally do. This looks like me 100 pounds ago, like frighteningly like me.
We can provide Ms. Boone a copy of our pro se packet that has information about, including model motions. We would have to send her a copy or send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions?
Missionary
the court
position.
Just identified.
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator.
Mm-hmm.
The JAC has no objection to authorizing $5,000 in costs for prison break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses.
See, I told you when we reviewed this last week, I said she's already won her first motion on the appointment and reservation of costs for an investigator, because one was already appointed for her before she even made the motion, which was the aptly named Prison Break Investigator. So they're going to say, he said, yep, congratulations on your first win. You get to keep the people that were already assigned to you. Plus you get the $5,000 that the JAC can provide. So there you go.
And the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them.
Wait,
deny
what?
those motions with prejudice, but that means you can refile them and we can readdress them.
That's weird.
When you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek.
So she wanted money for the for depositions and for witnesses. But he's like, I don't know who you're calling as witnesses. I don't know who you want to depose. I don't have any of that information, so I'm denying it. Once you get your shit figured out, once you decide who you want to call, who is on your witness list, who you want to depose, once you figure all that out, and you better hurry because trial's coming up real quick, then file another motion, and I will reconsider it at that time. I just have to dismiss it now because you ain't got no information for me to act on.
To depose, because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
Of course you do.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for. And again, I have yet to receive my discovery, so I don't even know who it is I need.
Okay, in principle, that's a good question. There was a deadline of July 22nd for all pretrial motions. It's like, hey, I don't even have my discovery yet. So I haven't been able to go through my discovery. So I don't know what motions I need to make or who I need to make them about or who I need to give them to. So what are you going to do about this time thing, Judge? It's actually a pretty good question.
So I understand for those. So you're telling me at a later date, once I have that information, to revise them.
I'm giving you the opportunity to refile. Yes, ma'am.
Thank you.
And I said you'll notice I said in principle, that's a good question. The reason I said in principle, and that's not actually just objectively a good question, is because as what the judge said, she didn't have to ask it because the judge already said she can do it. He already said you can refile once you figure your stuff out. So she didn't need to ask it, but she did. And the judge basically said what I just told you. I'm not what I just told you. The judge told her what the judge just told you. You can refile.
With regard to the defendant's motion for reservation of proposed costs to With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses, for the defendant's defense in trial dated July 18th, 2024, and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it.
See that? Remember when he said that the first motions were dismissed with prejudice? I said that's odd. He meant without prejudice. Because if something is without prejudice, you can refile. If something is with prejudice, it's over, it's done with, and you can't refile. So when he said with prejudice, he meant without prejudice. That's why I said, well, that's odd. So he said he spoke correctly here when he said their motion for money for expert costs. Same deal. I don't know what to tell you. You're asking for the expert costs. We don't know who your experts are, where they're coming from, what their rates are. Figure it out and file the motion again.
Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid.
Now, see, this is the thing. This is the last motion, and we're 10 minutes into this. Honest to God, what are they going to be arguing for the next hour and 37 minutes? They can't be arguing this lawyer, standby lawyer thing for the next hour. Please tell me they're not going to argue this for the next hour and 37 minutes. I'm actually really quite scared to move forward with this because I don't know what's going to happen. Burning Sensation says, Jeff, you should write a book, Pro Se for Dummies. It would be a very, very short book. It would say, hey, dummy, don't do that. Get a lawyer. And if one's appointed to you, be nice to them. That would be the extent of the book. LV Cowboy, what's up, LV Cowboy? Damn, for some reason I really want a nice old fashioned now. This is a delightful dark and stormy made with plantation dark aged rum and some wonderful ginger ale. Ginger beer is kind of hard to find here in Korea, so you kind of have to use ginger ale, but should be ginger beer and dark rum, but it's dark rum and ginger ale. But yeah, go get yourself an old fashioned. Nicola Maxwell, all the way from Scotland. Jeff, please never stop the intro chat. I love it. That's how we bond. Ah, it is. And I just deleted the other chat I wanted to mention. Oh hell, where did it go? Shoot. There we are. Discovery. Open the suitcase doors, Hal. I'm sorry, JKD Buck 76. I'm afraid I can't do that. All right, that's those are the comments that I just picked up while we were watching this little bit. So here we go. Back. Let's find out what the heck happens for the next hour and 37 minutes because I am stumped.
Aid in support and preparation of a criminal case for trial dated July 18, 2024, and received July 29th, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid in support and preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
All right, real quick, for those of you that may not be familiar with this issue, she has either hired or been appointed a grand total of 8 lawyers. Eight of them. And they were all incompetent. They were all mean. They were all unmotivated. They were all horrible, horrible people. And so she lost all 8. Either they conflicted out, she got rid of them, or they said, Judge, I cannot work with her anymore. Please, for the love of God, let me off this case. So through however you want to look at it, she ended up losing all 8 of her court-appointed or hired lawyers. And the judge eventually said, I'm sorry, you're out of chances. You have a right to an attorney, not every attorney. You've run out of chances. So from here on out, unless you have the money to appoint your own lawyer, you are representing yourself. That's why she's here today without her lawyer, because she is her attorney. And then after she lost 8 lawyers, she then filed this motion to please give her another lawyer to stand by and help her figure out what she needs to do. And that's what they're arguing here. And I have a very sneaky suspicion the judge is going to tell her to go pound sand. But let's find out.
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel.
You tell him, fat me.
Someone whose role is incenting not to get involved until the defendant says, I no longer want to represent myself.
That is a very, very good synopsis of what a standby counsel is. It's not your co-counsel. It's because she wanted someone to tell her how to file these things, what the procedural things are, help her out with the preparing for trial. No, that's called a lawyer. That's called an attorney. And he very, very, very eloquently put it that this is just not what happens. That's not what his job is. The standby counsel is just there in case, as he said, for people who have elected, who have voluntarily chosen not to have a lawyer, that if they go, oh my God, I'm in way over my head, holy crap, I need a lawyer, standby counsel comes in. There you go. And that does not fit this circumstance. Dina with the $10 super chat, making herself the vice racks of the day so far. Unless she's out super chatted by someone else, she will be our vice racks of the day. Dina says, amazing. No, Dina, you are amazing. You are the one that's amazing, and you have now brought us within $80 of unleashing the emotional potato cam pig support dog, or whatever the heck we're calling it. The emotional support potato pig dog cam. There we go. All right, folks, back at it, I said.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul versus State, 152 Southern 3rd, 635. Pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253 at pinpoint 258 from 1984.
Ooh. Wow. Literally giving her chapter and verse of cases to tell her to go pound sand.
As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se.
Simultaneously. I like you, Judge. You're just reading. He's just reading for speed, not accuracy at this point.
And with legal representation by the Florida Supreme Court in 2009 in Shepherd versus State, 17 Southern 3rd, 275 and 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
No, what the hell are we talking about for the next hour and 35 minutes? I'm so confused. This is really weird. All right. We'll find out here in just a minute. But first, been there, done that says with the $11 super chat says, hey, it's not Dina anymore. I'm the Vice Rax now. But shortly on the heels of that, we have Janice Wingfield with a $20 super chat saying, release the doggy cam. They're so cute. It's a Vice Rax bidding war. More than $20 to unseat Janice Wingfield as the Vice Rax of the day. All right, let's continue and find out what the heck is going on for the rest of this lengthy hearing. Silence?
Do you have any other questions, ma'am, as to the court's rulings this morning?
Yes. She has questions.
I do not forfeit my right. That was your judgment. And also, I feel that...
What? I didn't even hear that.
First off, I do not forfeit my right. That was your...
I do not forfeit my rights. He said, you forfeited your right to counsel. She said, I did not forfeit my right to counsel. And of course, the judge is going to go, yes, you did, because I said so.
And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel,
don't insult the judge.
Thank you to him for explaining to me what specifically it is. I don't want to be pro se any longer. So we're back to square one. She no longer wants to be pro se. She's like, oh, well, now that I found out that I don't get a standby counsel. Oh, and thank you for telling me what it is. I don't want that anymore. I want a real lawyer to be appointed. And the judges, this is on a loop now. We are on a Sarah Boone loop. The reason she asked for a standby counsel is he said, you don't get any more lawyers. You don't get any. You burned 8 bridges. You don't get a 9th bridge. So we're gonna have to see how this. Perhaps the judge is going to be very, very tolerant for the next lengthy period of time. But out of the blue with the mega $50 super chat.
Gotcha, bitch.
Oh, that was the wrong button. This is the button I was after. Sorry about that, Kyle Bodie. Kyle Bodie with the Canadian $50. Jeff, you don't understand. I need my emotional support potatoes here. This is too traumatic. Oh, well, we are just about there. We are so close that I can smell the bulldog breath from here. Thank you very much. Kyle Bodie with the 50 Canadians is now the Vice Rax of the day until something more happens. But until then, we got both of the dogs here in the room tonight. That's why I can smell their breath. We're going to find out what the judge is going to say to her when she goes, but wait a minute, I don't want to be pro se anymore. Now that I know I can't have a standby lawyer, I really want another lawyer appointed for me. Let's find out what happens.
I didn't want to be pro se in the first place. And then you, in my opinion, unlawfully denied me or didn't even suggest.
Take it up on appeal.
To avoid or try to go about a solution or remedy that you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period. With regard to an evidentiary hearing, that seems to be...
Okay, so that was the evidentiary. She wanted the evidentiary hearing. He's like, yeah, that's just denied, period. I like it. Just denied, period. Sibling Creature with the 20 Aussie dollars has moved us to that wonderful part of the day that we call
Release the hose.
All right, that was way faster than I thought. So while we progress here, we will continue with the hearing, and I will set up the doggo cam here in just a minute. as soon as they stop licking each other's nether regions, I'll put them on the camera. All right, let's go.
In the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is regards to competency as opposed to having an understanding before you take someone's right away.
Ferretta pertains to a criminal defendants seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explaining most of all of this, and as opposed to prior, so I would know what would happen or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence or the Ferretta hearing was simply competency. So the evidence.
Yeah, she's kind of right. The Ferretta hearing is kind of a competency hearing to see if you're competent to act as your own lawyer. But that's not an issue here because you're not asking to be your own lawyer. He's just saying you don't get another free one. You can have all the purchased lawyers, all of the hired lawyers you want. We just ain't giving you a free one anymore because you went through a lot of them. So that's a very different issue than whether she's qualified to represent herself or not. She's the one that's been saying she's smarter than all of her lawyers. So the judge is going on that. Okay, then. No, Mary Jane. Strawberry was not eating Yoda's butt. As you can see, Strawberry is chewing on a bone that just happened to be behind Yoda. What? Dina!
Gotcha, bitch.
Damn it, why did I do that again? I keep... Sorry about that again, Dina. That's what I get for moving my buttons. Damn it. Dina, watching from Seoul, will visit Busan soon. Nope, no stalking. No. Dina, you know where it is. You know, I'm down here, so when you get down here, let me know, and it's drinks on me. Hopefully, with far less bad things that happened than Halloween in Seoul a couple of years ago. Dina, just let me know when you're coming on down. As I said, any of you that happen to find yourself in this corner of the world in Busan, Korea, send me a tweet, send me an email, whatever, and we can do some drinks. Whatevs. All right, take care, people. Let's. I may have a stalker. Nope, no stalking. Nope. Just let me know when the date is, Dina. Thank you very much, and let's get right back to her confusion.
Evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my rights counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you presently.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
All right, that's the nuclear weapon from the judge. That's the nuclear bomb going kaboom. We do have a button that's not the gotcha, bitch button. This one. That was that one going off. First of all, she insulted the judge by, but you didn't read it. You didn't even listen to anything. You didn't, or you just don't understand it. He said, nope, I got everything, paid attention to it all. And doesn't change anything I said at all. So motion still denied. I still find that you have waived your or forfeited your right to counsel or waived it by your conduct. I did like that. It's like you either forfeited it, or even if you didn't forfeit it, just your actions, you being the way you are, amounts to a forfeiture. And Janice Wingfield with the $20 says, Miss I excel at everything and straight A student is finding out she's in over her head and isn't so smart. Yeah, she's finding that out in a big way right about now. Sorry, you don't get a lawyer for two reasons. One, you forfeited it, and even if not, you just waived it because you're just that bad of a person. Well, that raises an interesting question here from Knight 01007. So what happens if she doesn't put up a defense and refuses to act as her own lawyer? Then she's found guilty very, very quickly. And then she's got to find the money for an appellate lawyer. And unfortunately, the appellate lawyer might go, gee, did you make any objections to anything that you didn't like? No? I don't know if we really have grounds for an appeal. That would be a very interesting situation. Give them some grounds for appeal. Wow. Let's hope it doesn't come to that. I hope she puts up a vigorous and slightly off-kilter defense on her own behalf. But that was a very good question. It would just result in a very quick guilty verdict.
Okay. I believe...
yes, and Jules pointed out that she just during her little monologue, they're accusing him of retaliation. Yeah, don't do that. Don't call the judge names. Don't impugn their honor, and for God's sake, what would the judge be retaliating against her for? He sits there on that bench all day, every day, regardless of who's in front of him. That's kind of a really, really dumb thing to say. And oh, by the way, it doesn't make the judge like you anymore. It does not endear you further to the judge to say he doesn't understand things, he doesn't watch anything, he's confused, and he's just retaliating.
In my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorney.
God.
And by you reading and then also listening to the audio, you did not...
Oh, no. Sarah. No, Sarah, don't go down this path. It's a dark and thorny path. Oh, God. She's saying, I read your 16-page order, and it's full of errors, Judge, and they're all based on the fact that the lawyers are perjuring themselves. Oh, no. That can't sound good even in her own head. That while she's formulating that sentence, that can't possibly sound good to her. Oh, dear. What are you going to get out of that, Sarah? Judge, you're wrong, and all the lawyers committed perjury. That's why I'm innocent. No, oh God. Basilin, Cielin, I'm sorry, I have zero clue how to pronounce that. I understand the decision to deny her further appointed lawyers, but would it have been an option to keep the lawyer and rule her incapable of contributing to her defense? No, she is very, very capable of. If she's incapable of contributing to her defense, then she would be found not competent to stand trial, because that's that's the basis for being competent to stand trial, is that you must have a general understanding of the charges against you, the penalties that come with it, and you must be able to affirmatively assist with your own defense. So, yeah, that would render her incompetent. to stand trial. And the previous lawyer said, I can't work with this person. I don't want to work with this person. And just from reading what we did yesterday and a little bit before, it seems like that lawyer is saying, you're going to go down in a blaze of glory. You need to plead this thing out. We need to work on a plea deal to get you. And she's like, I don't want to do that. And the lawyer's just like, hey, she wants me to do things that I don't think I can do. This is a bad road for her to go down. Yeah. But it looks like she's going to go down for the next 90 minutes.
Listen to me in any way, shape, or form in order for me to explain myself better so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that is my opinion.
Well, the judge,
and like we talked about last time, ma'am, you're certainly entitled to that opinion.
are we done? What are we talking about for the next hour and a half?
All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th.
That answered the question we had here in chat.
Extended from 2 weeks to 3 weeks.
Oh, God. Oh, dear. Now, see, oh, no. Judge, you disappoint me, my friend. That answered Darby O'Hara's question. Darby O'Hara said, when does this trial begin? October 7th, he said. Now, I talked about this the other day, and I said what I'm hoping beyond hope is that the judge realizes this is going to be about a 3-day trial normally. But because Sarah's involved, he's giving a buffer for 2 weeks, if necessary, for the trial. But he just kind of shot that down and said he's going to extend it from 2 weeks to 3 weeks for trial, which means he probably thought it would go 2 weeks. And now he's like, oh God, we're going to need extra time for this, aren't we? All right, let's make it a 3-week trial. So, well, ironically, this is scheduled to wrap up on Halloween then. If that's the way it goes, it should wrap up on the 28th. So there we go. Exactly, a Halloween trial. Thank you so much. We'll call magic. It should wrap up right around Halloween. So yay, I guess. Oh God. I had really hoped he was just giving a Boon buffer, but nope. Dear. All right, so it's going to be 3 days, a Halloween trial. Oh, and just before we jump back into it, Lancelot 652, thank you so much for the $5 super chat. Can a state-appointed lawyer drop a client, or are they forced to stay? If there's a reason to withdraw, their client's not communicating with them, their client's asking them to do something unethical or illegal or immoral, or if there's some sort of irreconcilable difference. If there's a reason, then as the eighth lawyer and several of the other lawyers have done, they file a motion to be recused. They find a motion. It's basically a motion begging the judge to fire them. And if the judge will consider various issues and decide whether or not to let them off the hook. I mean, a judge can say, sorry, no, counselor, you have to stick with it. The judge can do that. So yes, a court-appointed lawyer, they just can't walk away. They need the judge's permission to walk away. Hope that answered the question.
Take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pretrial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th.
What? Thursday the
at 9
26th.
a.m.
Thursday the 26th, not Tuesday. You can't have two Tuesdays.
Yes, sir.
Yes.
That's Thursday.
Wow. So basically, they handled several pretrial conferences in one day. Here, the judge is like, look, we're going to need more than that. So it seems like the judge has just set aside an entire day for the pretrial conference. He's like, yeah, we need to separate this from the other business we have scheduled that day. So let's do that. Lugmeister. Of course, Lugmeister, everyone dress up and show up at trial dressed up as Boone with a suitcase on the last day. LV Cowboy pre-trial. Yeah, we need to get Judge Manning. Well, this judge is a great judge too.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay. All right. So pretrial will be rescheduled.
Yeah. What, like she's got pressing social engagements that won't let her come on the Thursday, but she could make it on that Tuesday. Yeah. Of course it's okay.
Until September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed you, but some of it may have been reviewed based on counsel's representations.
That indicates she may not have been truthful with the court because she was saying her previous lawyer only met with her like 15 minutes. He's saying she was there for 20 hours. That's a little different than 15 minutes. All right. Well, the truth shall set you free, Ms. Boone. The truth shall set you free.
State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
All right.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense,
Yeah.
and I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to
Extreme close up.
That's exactly the idea. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court.
Swan Lake lady says, take your raincoat off, dude. Well, see, I see what he's done here. And so I didn't say anything. Now, mind you, there was a hurricane blowing through yesterday. And what you can see he's done here is he ran off to court without his suit coat on. So he should have his raincoat, a suit coat, and his white shirt. So yeah, it seems he forgot his suit coat jacket. His suit when he ran out into the rain. So he's wearing, I guess, his trench coat, his raincoat, to just prevent him from not having any type of coat in the courtroom and just having his big bright white shirt showing. So, yep. He's just rolling with it. It happens to the best of us.
So that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
let daddy tell you what to do. That was the elder prosecutor explaining to the younger prosecutor. We saw a teaching moment. We just witnessed a teaching moment there. Say, here, say this, do this, let's go. That was that's a teaching moment, a prosecutorial teaching moment. We just watched and witnessed.
That's it.
So I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay. And that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list in the USB.
Yeah, we're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right
No.
now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality, it is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing.
Ah, boo.
So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trial.
Now, that's a very fair point to take. I don't like it because it means I can't cover that hearing, but it's very, very fair because they're going to be showing basically all of the tangible evidence. Like I said, all the stuff collected by CSI, everything that we watch them take out of envelopes at trials. They're going to be showing that in court on the first. And she says, but then everybody's going to see this. And he's like, okay, we're going to be collecting the jury pool from people in the area. So if we already show, before we select the jury, if we show all of these intimate pieces of evidence, that could be a problem. So he's probably going to make an entry and make an order prohibiting media access or media like camera coverage of the evidentiary items. So, Again, it's fair. I think it's correct. It's right. So you don't contaminate the jury pool. You don't give potential jurors a heads up on what's coming. But dang it, I want to see it.
Trying the case.
I understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail, and I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from
Mary Jane says, why do they call him George when his name is Jorge? Isn't that Jorge? He calls himself George. So, if he says his name is George, his name is George.
Prison break is that we identify those files.
Well, he called himself
that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections, such as duplicative or any other objections she may want.
So she's going to be allowed to object to any evidence at this hearing at the beginning of September.
Digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions, and then later we can turn to her request and put on the record how we would go about going out to the jail and meet her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it. The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator or she can review it with us, being present. And then that way the digital evidence is now in the open.
Okay. Ms. Boone, what are your thoughts on that?
I'm
A little lost.
So it's an option of reviewing what the state has with my investigator and then be able to come with the objections and everything.
That is correct.
I'm clear on having all of my evidence being in sealed bag.
Our peeps, I'm going to have to ask all of you to bear with me here for just a moment, because JKD Buck and good friend of the channel, Shizzy Wiznut, have both sent me a link to the hearing with enhanced audio. Let's see, make sure it's not the same length. So we're going to have to approximate where we are in the grand scheme of things. So I want to bring this up with the enhanced audio so that I guess it's going to enhance her a little bit better. So I'm setting this up as we speak. Let's see. I'm going to see, we are in this video, we are at the 31:19 mark. Let's go to the 30 mark here and see what happens. It doesn't sound that much enhanced to me. To me, it's actually harder to understand because her inaudibility is just more than it is on this one. If that makes any sense. So what I'm going to do here is I'm going to put it up to you guys and see which you think. This is regular audio. This will be number 1 in chat. So here's her audio.
For me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So
that is audio 1. And then audio 2 is this one here.
I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet.
So what we have is we have the original audio with closed captions, or we have this number 2 is this revised audio without captions. But 1 or 2, whichever one you want to go with here in chat. Been there, done that. 69 and 420 doesn't help right now. Need legit votes. And it looks like it's just about split. You too, JKD Bug. Two seem to be having it. Seems to be. Oh, God, it's right about 50-50. Damn it. It wasn't a blowout either way. All right, it looks like 2 is kind of edging it out a little bit. So we'll use audio 2 here. And let's see, we've got 31, 41, 116, so 24. Looks like we're about We have to go back to right about here. We'll start here. And just,
Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail. We're not publishing all the digital evidence.
all right, I'm calling an audible on this. We're going to go back to the original because it like hers, you can sort of kind of understand a little bit better, but everybody else just sounds loud and muffled and muddy. And just what is a Shizzy Wiznut? It's a great channel. Go check out Shizzy Wiznut. It's a good guy. We're going to go back to number one just because I can't hear it. It's Agony Goose says it's muffled like you're inside a suitcase listening to her. The authentic experience. Yeah, please go back to the other one, please, with closed captions. Yes, because we do have a number of hearing impaired people, myself included, that occasionally rely upon the closed captions. Plus, I think it's a little bit crisper. All right, apologies for that little side quest there we just went on. Hey, what's up, Strawberry? All right, back at it.
I'm just trying to protect myself against the media.
She's really focused on the media, isn't she? She's not focused on her case. She just doesn't like the media. So she's far too concerned about the media.
I'm not sure at this point what is even suppressible that is available on the internet. But at the same time, though, it is my understanding that I should have some right to privacy in reviewing the evidence. So I didn't know if my investigator and I are able to collaborate prior and view and then come to court with everything finalized and ready to go with answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, et cetera, would be addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it, but it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either.
Yeah.
So that wouldn't really be any different than if she's doing it in the witness stand or wherever you deem suitable in court.
That's a good point as well.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it
Fair
that
enough.
it can't be transported anywhere other than here?
Where do you want to go, Burger King?
Because I cannot make a record anywhere else of what you saw or what was reviewed.
It's like, why can't I be sent anywhere else?
Make that record.
You got jail or court?
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term. And then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
So he's saying it's just basically the same thing that we have to do. We can do it at the police station or the police warehouse, the evidence warehouse. You have to do it in court. Otherwise, the same people doing the same things are present.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
No.
That's a conversation that I need to see.
He's going
if
to
I
say
can
no.
exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed.
If there's
I need to
any
see if
way
I can,
possible for the judge to prevent the media from being at that
media
evidentiary hearing
so without
thing,
doing a little bit more further
he's going to
research,
deny
I
it.
don't know if I can make that
He's going
call
to deny
at
the
this
media
time.
presence if he can.
Yes, I have not heard of a case where the evidentiary hearing has been televised.
I have.
So, if you could
I
look
have.
into that, 'cause I disagree with the media being involved in that.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing
To be the second
for
Thursday.
Tuesday,
Yeah.
the 3rd at 9 a.m. to have the physical examination here in court. At that time, the USB drive or the after our viewing here in court, state is it your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically?
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion.
Okay.
It seems like we're turning that discussion.
It's very nice. We'll just do whatever
So
the
I'll leave
defendant
it to
wants.
Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past with female defendants at the Orange County Jail, there are classrooms, at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss.
Oh, Sarah wants to
It would be
discuss
recorded
something with
and,
the prosecutor. That's interesting. Apparently, she wants to discuss something with the prosecution, and they're willing to go out to the jail to talk about it with her. That's interesting. Is she trying to negotiate a plea bargain for herself? I doubt it, because she thinks she's innocent.
Is the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I can leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use. I don't know that there's a whole lot of other digital evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior, before everything else.
Whenever it
What
gets
I would
done.
envision, to not waste anybody's time, is we can go out there and have this discussion. If there is a discussion to be had about plea offers, One of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
Ooh, so there might be a plea discussion to be had with the prosecution. And apparently it's something she has asked for. So I think that's interesting. We'll have to see how that plays out. But while we're paused here, just a couple of things I wanted to hit. We don't have any super chats currently, but LV Cowboy says, what if she just objects to everything? Then it'll be like the Darrell Brooks trial. It'll devolve into the Darrell Brooks trial, which I hope it doesn't. But Night Owl, Sarah Boone needs to file an appeal to the decision that she's shut off from a lawyer. It wouldn't hurt, but again, she doesn't know she should. That's the problem. Ugh. Legal-minded friends, Karen Cole. How you doing, Karen? Good to see you. She's been tried by the media as a crazy person, and she's done nothing to dissuade people from having that image of her. That's the problem. Sometimes it's not inaccurate. Ugh. And Karen D. I think the media should be kept away from that process. I agree. I want to see it come out at trial. I want to see it at the evidentiary hearing. I want to see it at the evidence, but I agree that for the purpose of potential tainting of the potentially, not for the purpose of, but to avoid the potential tainting or polluting of the jury pool, I think the media should be kept out of the evidentiary hearing process. But again, the judge said, I have to look to see if I can exclude the media to see how that sits with the right to, open with the right to attend open hearings and things like that. So we'll see how it works out in the end. Oh my gosh, we're $10 away from unleashing the second goal achievement. Weird. Didn't expect that.
So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of
so 3rd of September.
So we would have a hearing at 9:00 in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide.
While they're talking about this, hang on, I'll be back in about 30 seconds.
And they would identify
I'll be right back.
Specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So
Her jail calls have been released? I haven't seen any of those.
I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously had worked on the laptop with USB drives that he has furnished himself from bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain, whom I spoke to the other day regarding my laptop.
It has to go through the jail. They can't just hand you the thumb drive.
Sorry?
Who was that?
For which?
The captain that you spoke to, who was it?
D. Giovanni.
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring in with me prior.
Well, it's still got to go through the
If I
regular
understand
process.
the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created.
It's for safety and other
the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department.
So you've got the thumb drive with the evidence on it.
So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
He literally read it to you, how it was going to go down.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple.
See, the judge is calling her bluff here. Oh yeah, who told you it was different than I did? Give me the names. He's calling her bluff here. And I think it's a big bluff to call because she's saying her jail phone calls have been released out into the public. I haven't seen that. And I challenge any of you to tell me honestly that you've seen or heard her jail calls anywhere. As far as I know, they have not been released anywhere. She's just hollering here.
What are their names?
I'd rather not get them involved.
I'd rather not get them involved for fear of harassment. Bitch, that's the judge. That's the judge is telling you. In other words, when the judge is telling you, I want to know who these people are that told you that the process is different than what the jail told me, he's saying that, one, to call your bluff, but two, in case you're correct, for your protection. So you best either you give up the names or it just didn't happen. Those are your options. I'm sorry, and there's nothing else that you can say that will make me think that that actually occurred. So if she doesn't want to give the names, that never happened. No way that happened.
Or anything from other.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and it was provided by U.S. mail. It was sent out last week.
I have yet to receive anything such as.
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your.
Daisy Loves Derek just stumbled across your channel. Thank you for covering this hearing. You're quite entertaining. Oh, thank you very, very much. I hope you'll stick around for a while. I hope you hit that little subscribe button down there and hit the notification so you get more notification of what's going on. We're following this case all the way through to the end. And I said we got a Karen Reed hearing coming up at the end of the week. Every Thursday we do a retro trial. We're doing this Thursday. We're doing the retro trial of Florida v. Donald Hartung. It was a 2020 case involving a 2015 murder of an old elderly gentleman who was accused of murdering his half-brothers and his mother in a witchcraft or ritualistic manner. And as we found out last Thursday, they can't rule out the possibility that ferrets murdered the family with a hammer. So we got lots of things going on here on this little old legal channel that we call Legal Vices. So welcome aboard, Daisy, and I hope you stick around for a long time to come.
Order that you provided me with the implementation of your USB drive
Okay.
option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process,
It was served by U.S. mail.
Yep.
by US mail?
Yep.
Yes. I actually have 3 motions, please, if I may submit them to you.
Oh, no.
Yes, in the process of, because the address.
Ladies and gentlemen, Sarah Boone has 3 more motions to file. Guess what we're going to be doing a few days from now? We're going to be looking at those 3 new handwritten motions that she's going to be submitting to the court here in just a minute. But speaking of just a minute, Duncan Idaho, with the member for 17 months. Thank you, Duncan. Appreciate it. I appreciate the meticulousness of the process, but Jesus, lady, you're sunk. The evidence is all there. What are you hoping to get? Slam dunk. Well, like I said, we have to maintain the innocent unless proven guilty. But yeah, she's going down. I mean, there's no way around it. And Jacob's proud madre has just hit us to the second goal. Thanks, Jacob's proud madre. But I had to go to get the second. Our second goal, our second goal that we achieved, the $200 mark, is to make a dent in horrible whiskey that I wish I didn't have. So this is the way of finishing it off. It's been so long since we hit goal number 2 that I actually moved it back to the whiskey room. But it's Costco Kirkland brand blended whiskey. This is bad stuff. This bottle has been untouched. I don't know how long I've had it, but I know it's been untouched for about 5 years. So we're just trying to burn this off. So the second achievement is the punishment shot. Thank you very much. Ha ha ha. Jacob's proud madre for the Kirkland blended Scotch whiskey, 80 proof shot. Thanks. Oh God, I can't believe I used to think that was good. Whew. Yeah. Thanks, Jacob's proud madre. You are an awesome person, I guess. Thanks, but no thanks. Oh God, it burns. All right, there we go. Thank you very, very much. How do you know she's going down? Did they rule out ferrets? Different trials, same state, but could have been the ferrets could have zipped her up, but there was no blood to test, so it could very well have been ferrets. Let's not confuse new viewers any more than we have to. Oh, thank you so much. Now we are officially $95 away from goal number 3.
I'm guessing sending these 2 is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, if I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to.
Oh God, don't write another letter.
In jail. So by me trying
to stop delaying the process.
It's going to be a feat in itself. So I want you to know if anything that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Department withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing.
It's like, thanks. I'm just going to do what I said I was going to do.
So here's what we will do. We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
And can caveat in that order be unless it hasn't already been done? In case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th. And if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections, and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence.
Yes, all of the evidence.
Here in the courtroom.
Yes.
Correct.
And then later that afternoon, I would be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Billy
Your
J.
last name, please?
J-A-Y. Don't get that.
And what is your affiliation with the state?
I'm a homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time.
Yeah, you should be okay because, as we've said, you don't have any pressing social engagements.
Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
Then you can do that. And like I said, Mr. J, if you could follow that notice, just identifying when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to going in the process of working on it for the laptop. I do not have my discovery as of yet, and I do not have the laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already.
Okay, I will say I agree with her. God, what was it? It's almost 2 weeks ago. The judge said to give the thumb drive and she would have a computer. It's been almost 2 weeks and she doesn't. So I think she's got a valid complaint here that, she needs to get her stuff now. So I'll give her that.
I'm trying to figure out when and where I'll be able to view anything, so.
They just told you there's a
There's a
classroom that
Rate
they're going to
restriction
arrange.
also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quotes, the laptops in quotes, closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of. Neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime.
Okay, that's an interesting thing. And we talked about it previously when the judge said that she'll have access to this laptop from 8 a.m. to 4 p.m. And I said, well, what if she wants to work until lights out at whatever time that is, 8, 9, 10 p.m., whenever lights out is in her facility? She's not allowed to do that because she doesn't have access to the computer. I think that is a valid argument that she has. Unless lights out is at 4 p.m., which I highly doubt, then she can argue, I don't have time. You have to minus the time that I have for lunch. And I'm sure dinner gets served pretty easy because usually breakfast is served at like ass o'clock in the morning. So I think she's got a legitimate argument here that she's not given enough time to access her computer. So yeah, I agree with it. And I mentioned this last time. I think that's a strong argument, but she also wants hard copies of all of her evidence. Well, the reason they're giving her the laptop with the thumb drive on it is she's been complaining that she doesn't want people stealing. She doesn't trust the security of the facility and she doesn't want people stealing her evidence or jumping on her case. So you can't have it both ways. You can't say, I don't trust it. And I don't, it's not a secure facility and I'm worried people will steal my evidence, but I want my hard copy evidence. That's a weaker argument on her behalf. And Janice Wingfield with a $10 super chat. I read she already turned down 2 plea officers. Damn it. Stop saying officers. 2 plea offers, 15 years and 10 years. She's too much of a narcissist to accept a plea deal. But it's interesting that she is the one that requested this meeting with the prosecution. So we're going to have to see whatever comes of that. Chloe Albert's Revenge says, did you see the wanted flyer she made for an attorney? Yes, we'll probably be looking at that around part 3 or part 4 of her 58-page love letter to the judge she sent. But yeah, so I think she's got a good argument with the time that she's been allowed to use the laptop, but not so strong of an argument for hard copies. The way to deal with both of those is to allow her additional time until lights out to use the laptop.
Please, so you're aware of what I have already thought of and am trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by bringing that topic up, I have that to also be looked over.
Okay.
Please. 9/17, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And that will give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state.
Okay, now you're saying that the deadline for them to get you the evidence is September 3rd. If they get it before then, cool. But the latest they can get the evidence is that day. And then you'll have 2 weeks to make any objections to the evidence that they want to present against you. That's cutting it pretty close to trial. That's putting it 3 weeks away from trial. That's pretty close because he still has to consider the objections and rule on them. He's cutting that October 7th start date pretty close. Duncan Idaho with the $5. If she begged the judge and promised that she would accept whatever counsel has appointed her and be good, you think the judge might budge? Man, like I said, she has burned a lot of bridges. My gut would tell me that the judge is just, maybe maybe there's a possibility. But I think the judge is pretty much, this train has left the station. We'll leave it up to the appellate courts if it gets there. I think that's kind of where he is.
State seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I am very weary to make these type of deadlines.
Well, we're setting them today,
I understand. So the 3rd is a what day? Thursday?
Tuesday. So the 17th would be 2 weeks later, Tuesday the 17th.
And that is me coming with my objection.
That would be you filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Forgive me. So today being August 5th.
Yep.
I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
So by me not even seeing my discovery yet 2 days, and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
You have 62 days to prepare for trial, not including today. And you're going to get your discovery today.
Okay, so she'll get the discovery today.
Wow.
That's good.
So in over 4 years, it comes down to me representing myself in 62 days.
I'm not going to answer that question.
Am I supposed to?
What now we're addressing, ma'am, is September 17th,
Right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most, rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for
Oh,
you.
that's why you don't. That's why you accept and work with the court-appointed lawyers you're given, because Sarah, they know how to do it. When you burn all the bridges and you're no longer allowed to have a court-appointed, and she's not being denied her right to have a lawyer present. She's just been told she can't have a free one because she's burned through a shit ton of them. And those shit ton of defense lawyers that you've burned through, they all know how to do these things. They all know how to file these objections. They know how to make these answers. This is all on you, Sarah. Your behavior has led you to this point.
That would be me providing you legal advice.
Which he cannot do.
I'm prohibited from doing.
Yep.
All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. And those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay. And if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yay or nay?
I don't know what that means.
I don't either.
What do you mean delegated?
I was going like, what? You keep using that word. I do not think it means what you think it means. What?
Delegating to me as because you've delegated everything else in regards to taking my counsel and all of your orders.
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet. Your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable, I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also, if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier.
You don't get to do that because you blew that's a phrasing problem. You burned through 8 other lawyers.
I don't know either if you all are.
You don't get a freebie. All these questions you have, all these things that you need to do can be done by a lawyer, but you don't get a free one because you have burned through so many of them. If you can hire someone, if you can pay money to a lawyer to have them do this, you are welcome to have them here and they will take care of all of this for you. You just don't get a free one. That's it.
Proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date and then not be able to meet it, what happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question.
Yeah.
I'm not allowed to.
I think we're seeing the reality of her situation descending upon her right now. I know Karen Cole here was saying, how is she sane? I think she's sane. I think she has issues. She may have some sort of megalomaniacal thing or some serious narcissistic issues where she thinks she's better than everyone else and she knows more than everyone else, but I don't think she's insane. She's actually doing quite well as far as the motion filings go compared to other people. And like I said the other day, her motions are at least beginning first year law student level. I think she's clearly sane. And even if you're insane, you can still be found competent to stand trial and to represent yourself. I mean, it's I would feel bad for her if she hadn't have brought this situation upon herself.
So whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay. All right. Now, ma'am, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address deadlines for any exhibits or witnesses that you may be seeking. I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in
Toadette with the 6 euros. Thank you for covering this. Well, thank you for the super chat. And thank you for being here. Thank you.
The list
Appreciate that, Toadette.
of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testify in a defense should you choose to put one on.
Please understand that I do not have access to a normal phone.
Okay, he's asked her how much time she needs to give her witness list and her evidence. She's got a good argument. She doesn't have her discovery yet. She has no idea. How can she say how long she needs to prepare a witness and evidence list if she hasn't received her evidence yet? So, I think and I have no idea because I haven't received my discovery yet is a good answer to this question.
I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call that I do not have regular access to. And
If only you had a lawyer who could do that for you.
Minutes that I have to share with 62 other inmates. That is a hurdle please that I need for you to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
And good point.
I'm unaware. I can't answer the question.
Your investigator can call them.
I'm unaware if it has internet access.
Whom is it that I need to speak to in order for this?
We may be able to inquire of the jail representative who is appearing for the hearing this morning. And if not, the captain may be able to provide that information, but I do not know if it has internet access.
May I ask your contact names from the jail?
Give us 1 second.
Please, and also because of the court's error of sending my information that you're referencing to the incorrect address, could you please provide me a copy of that also?
What is it that you're asked? The protocol, ma'am? That was what was most recently sent.
I don't know. Whatever it is, the last thing.
The stuff you sent to the wrong address, can you send it again? I don't know. Well, what you're talking about, which address? I don't know because I didn't. What?
I received from you in the court was the hand delivery of the order regarding
Sure.
USB.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after. What I did. Oh, I sent it to Anita. That's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
So understanding that as of right now, you do not have hard copies. You'll be provided digital copies. And to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses?
She has to see the evidence before she can answer that question.
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have.
That is the good answer. I don't know because I haven't seen the evidence yet. I don't know who I want to call as a witness. I don't know who I can call as a witness. I don't know who I should call as a witness. So how do I know when I can give you this information? I need to see the discovery first. That's a good, solid answer. Congratulations. And also we have an Aussie Overlord raid. Welcome, Aussie Raiders. Great to have you here. Hit that like button, folks. And I guess let's really quickly stop here. And we're at the 2-hour mark. We should be finished with this, but I talk a lot. We're just over halfway done. I promise we won't go more than another hour. But let's do this. We have our like and subscribe poll here. We got 728 likes and we got 506 likes and 728 votes. 220 of you have cheated and took the like poll without actually hitting the like. Just reminding you, hit that like button while you're here. And there's 800 people here watching right now. I'm sure there's at least 1 or 2 of you that haven't subscribed to the channel. So please, during this short 30-second break, do me a favor and hit that subscribe button because I know you want to, and it would make me feel all warm and fuzzy inside. I would deeply, deeply appreciate it. And hit the notification button as well, because we're going to be continuing to follow this. We've got the 3 motions motions she said she's filing here. They might argue them here today, but they're going to be filed online. We'll review those as soon as we can. We're in the middle of reading a 58-page letter she sent to the judge. We've got a lot of Sarah Boone coming up. We've got a Karen Reed hearing at the end of the week, and we got a bunch of other stuff to cover. So make sure you're subscribed to the channel and hit that like button for the stream today and take our like and subscribe poll. Sarah Boone, 10% of you said she's got an airtight defense. 15% of you said she's got baggage, but I can fix her. 33% of you say, well, just stop it. And 42% of you say Sarah Boone will have her case zipped up tight. That's just our silly little poll. We'll look at it again at the end just to see where we are. That was just a quick little 30-second break to remind you to hit the like and subscribe. And let's continue.
There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers. I cannot promise anything because
The first thing you need is your discovery. Tell him you have to look at your discovery, and then you can tell him how much longer you need to prepare the list.
Understanding of a meeting that I would like to have with the captain, so I can see if I can have access to a regular phone, if I can have access to an internet. Right now, I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone. I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to be determined deadline at this time. I understand that there's been some delays with regard to discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
If the defendant's not going to make a suggestion, make a state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to be used at trial is provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her, would be our suggestion.
Okay. Ma'am, are you amenable to that? That would 14 days after you've had the opportunity to review the digital evidence, and 14 days after you've reviewed the physical evidence to provide your
That is
exhibit
so
list.
close to trial.
I don't feel comfortable with any of this.
Well, tough shit.
I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these things which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances. That I being
They understand your
not having
circumstances.
access to the phone, not having access to the internet, and not having access to many more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I'm stating my good causes now, if not, there are additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Mr.
Okay, all right. I will set a deadline for the review of September 26th.
Thank you.
Jill, yes, this is yesterday's hearing.
That is correct.
Yes.
I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get in that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. You'll have to provide that to the court in writing by September 17th.
Yes, and if I may ask, please, what you're typing, is that for an order or for today's proceeding?
It is for an order, which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm gonna have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to the your proper address. Due to that clerical error, that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts. Thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Other than what I have made known to the court, I do not.
Okay.
All right.
Bruce,
Good.
Can you see if Mr. Sergeant Casey's here? He is here. All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in.
All right. What the hell's this?
You can stay to the podium, sir. No, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk's going to go ahead and swear you in.
Lancelot 652 says the judge didn't eat a bottle of aspirin after this hearing. Probably.
Casey.
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown court holding, BRC courts, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come on up here, please, sir? Sir, good morning. Could you raise your right hand? Madam Clerk's going to swear you in.
You swear or affirm the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, sir, good morning. Could you state your name for the record for me?
Willie Lane.
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir, last time I saw you, I had tasked you with digitizing 2 banker's boxes of information. And you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those. This drive here is a copy of all digital discovery that I have in my possession from Ms. Boone for the court's needs if they wish to facilitate that through the, figure it'd be easier to facilitate it now through the jail
than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the two bankers boxes, correct?
Oh, JKD Buck pulling the Battlestar Galactica reference. Yeah, the jump drive. Jump drive. This isn't Battlestar Galactica yet. Nice jump drive blast. That was good.
And the other jump drive that was the larger of the two.
That was good.
That jump drive is
like
any
that.
digital information that you've had previously by virtue of being the investigator.
Yes, sir.
Okay, all right. The record's going to reflect that information is going to be hand delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, if you could please take custody of those two thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop. It'd be available for Miss Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No, Your Honor.
Okay, sir, thank you very much. If you can proceed with that task, I appreciate you.
All right, nothing out of the
Thank you.
ordinary. Just here is
Mr.
your
Lane,
here
you
is your
took custody with you,
discovery.
sir, as well. Before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocols provided to be by the captain of the jail?
Mr. Casey, could you please?
All right, before she answers her question, we have a homeless and lonely Koala-Bee-Roo here with Aussie Overlord all the way from Australia. It's a Koala-Bee-Roo.
When I asked if you had room for a stowaway, it's not quite what I meant, but anyway.
Well, we have our Koala-Bee-Roo here. Well,
So you've endured already an hour and 13 minutes of this. How is it not blood coming out of your ears? How bad's it been?
oh, it's very good. It's fascinating. It's not so
Okay.
bad.
All right, well, don't stop on
Not
my
so
account.
bad. Well, pretend judge was Sarah Boone has called her previous lawyer a pretend judge. Toilet Hooch Fund. Thank you so much for the $2 Toilet Hooch Fund. We all need some after this. Well, I just had my shot of Toilet Hooch from unlocking the second achievement. Hopefully, we won't have to do that anymore. But
Ooh.
there we go. Thank you so much for that, pretend judge, if that's your real name. Let's get back to her question regarding the providing of her discovery on this jump drive.
Please make note to Captain Giovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved.
I'll look for her.
Please, in regards to the laptop.
Okay.
Thank you.
Laptop issue.
Thank you very much, sir. Mr. Lane, when we were last here, you also had two bankers boxes. Did you bring those back with you, sir? Okay, could you bring those back up?
Here's all the evidence he has in his possession in these two quote unquote bankers boxes. There's all the evidence.
I do see it looks like the original exhibit tags are still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes? Okay, I'm gonna have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, Your Honor. Thank you.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And my only question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
It's going to be my intent to try to get out there at the end of the week or beginning of next week.
Thank you.
Nope. We got a court TV thing here.
I don't feel comfortable signing your invoice. I think Ms. Boone.
Well, that didn't last very long. So
I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign it.
Okay, that's fine.
Okay.
Is it okay if I?
Hand it to the deputy. Deputy will have her sign it, and then you can take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Boomer.
That would be acceptable, yeah, Mr. Lane. And you know, in light of this, maybe it might be more appropriate for the court to go up to 10,000 for the investigator, because it sounds like he's already done a lot of work. So it might make more sense instead of having to come back later.
Would that change?
All right, so Fat Me there is being very, very generous, and they'd already authorized $5,000 for her investigator fees, and he just bumped it. He just doubled it. He just gave her a twofer. So he just said, now you get $10,000 for your investigator's fees. So hey, win for Sarah Boone.
change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think would make sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
One thing I would like to add, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses and some out of county. If not, I can get that in some type of form of a writing and get it to you or to the JAC. If that's acceptable.
Mr. Lake?
Your Honor, we'd have no problem with the court authorizing, saying that $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need a word for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will prepare the order and submit it.
All right, very good. Just send it to Ms. Barrios, who I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thank you, sir. Mr. Lake, thank you so much, sir.
Yes, sir.
All right.
Judge Payne,
Yes, ma'am.
forgive me. What is his name, please?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants.
He's the guy you asked for money in your motion.
States from a scheduling perspective or the protocol, which I know I filed a notice of filing of. I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of witness from.
He will be
the
there.
site also.
He will be there. Mr. J is going to be recording the conversation as he identified previously.
Thank you.
The camera is your
Ma'am,
witness.
you made reference to some motions that you may have brought with you this morning.
Oh, we're gonna go over her motions. Cool.
Yay! Here we go.
Well, we've only got 30 minutes left, so I don't know. They're either gonna suck really hard, or he's just gonna listen to it and go, "Meh." We'll talk about it later. But when they're uploaded, I'll make sure we do a separate reading of these things. But Chloe Albert's Revenge with the $5 super chat says, I got it. He smoked a lot. He should have survived, but his lungs gave out. Not her fault. There, I'll represent her. I guess not any worse than whatever she's going to do. So have at it, I guess. All right. Oh, let's see how detailed they get with these three motions. She says she's brought with her.
All right, if you could hand those to the deputy. Also,
Extreme
to the extent
close-up.
the deputy has not already done so, I printed out a copy of the July 24th, 2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you. It was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I have not received this yet.
Okay.
Well, you just did.
And then also there was another printout that she was going to provide me with, which I believe was a memorandum for today's date.
I haven't, is she being who, the captain?
No, I'm not sure her name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order. And like I said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document.
Oh no, this is a little bit of breaking news. So we'll interrupt this very, very briefly. Presidential candidate Kamala Harris has just nominated Tim Walz as her vice presidential running mate. He is the governor of Minnesota. But within minutes of her announcing him, the Minnesota governor, Tim Walz, as her vice presidential running mate, it seems that a group of veterans have released a letter regarding his history of stolen valor.
Ooh.
It's about to get interesting in the presidential run, folks. Just throwing that out there.
Ooh.
Yeah.
I have some Googling to do.
So yeah, apparently there's a little bit of stolen valor allegedly involved with the Kamala Harris appointment of Tim Walz as vice presidential running mate. Yoink. All right. Well, that's not what we're talking about here today, but that was something that just scrolled across my computer.
Proposing the dates for today's hearing. And I guess it was some type of notice. That's what brief that she was going to print out to give to me, so I had that.
Okay. Mary.
I did not receive that, nor did I receive this protocol list.
As to everything that was being discussed, can you print out a copy of it first? It should be in the court file. All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
All right, we can skip through this a couple of moments. He needs to read through it. We don't get to read it.
Well, ma'am, with regard to one of your motions, the motion for defendant's immediate address correction, as identified earlier, there was a clerical error using the
address
general,
correction, no big deal.
PO box as opposed to legal mail. That's been remedied. So I'm going to go ahead and grant that motion as that's already been remedied, but I don't have a problem granting your motion for the correct address for any legal mail.
Right. Well, that was an uneventful motion. Address correction. Okay.
Mr. J, if you want to approach, sir, to review the hand-delivered motions, it is the motions for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. Second motion is the motion for defendant to lawfully receive, review, utilize the original hard copy discovery, parentheses, 2 boxes, -A, B, parentheses, submitted to the court by former attorney, parentheses, S, and parentheses, on June 28, 2024, for preparation of trial in her criminal case. Just review those, counselor, just let me know when you're ready to address them.
Your Honor, in regards to the first motion, we need to notice the sheriff's office, who is in charge of courtroom security. So we're not able to address that today unless they're allowed. I don't know if you're able to contact the person that's in charge of that today. Otherwise, we would need a separate day for that motion.
Okay.
As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Okay, all right, I appreciate that, sir. Ma'am, with regard to your request for discovery, the hard copy discovery, you've advised me multiple times seeking to use a laptop. I've written correspondence from you asking for a laptop.
Mm-hmm.
That laptop is being provided.
Mm-hmm.
At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in the female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small.
See, that's what I was saying earlier. She wants all of this on a laptop on Thumbprint because she doesn't want people jumping on her case. It's not secure. She doesn't have any privacy. People can steal her documents. There's nowhere to store it. And now she's asking for hard copies so she can work after the 4 p.m. cutoff of the computer time.
Small drawer to keep personal effects, and that's it. There's nowhere, is my understanding, in communications with the captain to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Or are you asking me?
No, those are just statements that I know that are in the court file that you've made.
Mm-hmm.
You've written letters requesting a laptop. That's been provided to you.
I've never,
You have written letters, ma'am, specifically asking for a laptop
do you know what the date of that is?
without me going through all the correspondence. But when we have our hearing on the issue of the your motion for freedom and movement, well, I'll notice the sheriff, and we'll try to set that up for this week so that it can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you. When you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by sergeants.
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk. Help me understand, please, for future reference, so I know how to approach.
What?
By my statements that I made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time that we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued like my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion.
Mm-hmm.
The process was created, and I'm just reciting what you've said to me at prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag or property bag that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those 2 bankers' boxes. Ms. Berrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers' boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form, it was in digital form. And that was the process that the jail created. They are aware it's 2 bankers' boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
My opinion differs. I was never asked anything, just like my letters to you prior to you forfeiting my right to counsel. I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
I am not, you never asked me in regards to the hard copy.
Hang on, yes.
How quickly can we have an evidentiary hearing with the captain or whomever we need?
My understanding is she's on vacation this week. So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she's set to return. She's set to return on the 12th.
So,
all right, 5 more days.
If the document, what would be the process? Because it's marked, tagged, and in evidence, so there would need to be a motion to get it released from evidence.
I mean, I would entertain an or tennis motion to have it released from evidence. The concern as, and Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. We had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver. And I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those 2 banker's boxes that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those 2 banker's boxes because of A, storage, and B, because of the hazard. Now, if the jail is in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
I understand. I'm just trying to find a solution. So if she moves or tennis to release those 2 exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th, we can revisit this when the captain's back.
I think, I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lane's had this discovery. I don't have a problem with him taking custody of it again. And if he's able to deliver it to the jail and they allow it to be released to Ms. Boone, I don't have a problem with that. I have no problem with it. I'm just traveling on what the jail has advised the court in the creation of this process.
Mm-hmm. Okay, sounds reasonable to me.
So if she wants to ori tennis, which means oral motion, move to release those 2 exhibits, the state.
Sarah, make a motion to make a motion to release those 2 boxes of evidence. Do that right now, Sarah. Open up your mouth. He just told you to open your mouth and say, I move to release these 2 boxes of evidence.
Can't really give any more of an elbow to her without being more obvious. Like,
is she going to do it is the question.
Oh, I doubt it.
And I mean, the judge may even go so far as to say, Ms. Boone, if you were to wink, wink right now, wink, wink, make a motion to release this, that would get us 1 step closer. Let's see.
I doubt the judge is going to do it, though, because then he's got to put up with her doing that the whole way through.
Yeah.
It sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near time future.
Yes.
Just so that she's advised. So I don't want to ask her, but perhaps the court can ask her. That's what she wants to do.
Ma'am,
there we go.
The state has recommended a position for in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask of that of the court orally this morning?
Say yes.
I'm not understanding what it is that he's trying to do. May I please propose that the hard copies go to Mr. Lane, and then once I have permission by the captain and whomever, he can release them to me?
Granted.
No objection.
Mr. Lane, thank you for staying, sir. I appreciate you. If you
see, that's what happens if you have a lawyer. It would be that easy at the beginning of the hearing.
Yep.
Don't burn through. Look, if any of you, there's currently 800 people watching. If any of you 800 people ever find yourself in a situation where you need a court-appointed lawyer and the court-appointed lawyer is given to you, do your best to work with them. And certainly don't burn through 8 of them. For one reason, or hired and appointed, don't burn through 8 lawyers, because you're not likely to get I can't believe she got 8 lawyers personally.
I'm surprised that after the first few that even the paid ones agreed to sign on, and then she had to get appointed ones. That's just it's batshit crazy to me.
And we got Chloe Albert's revenge with another $5. I said represent her, not win. I'm not a lawyer. I'm a rehome German Shepherd. Jeez. All right.
You can come back up here, sir, and take custody of both of those bankers boxes. I will have Ms. Barrios coordinate.
Prison break investigations guy. This evidence is now your problem.
We cannot do it the 13th because it's pretrial. You're correct.
Pretrial.
We will have a hearing on August 14th, if necessary.
He's like, fuck, I just got rid of these stupid
Wednesday,
boxes.
August 14th at 1:30, if we need to address the jail's position in taking hard copies.
Lift with your back
to have it delivered.
No.
Mr. Lane, you advised.
Please lift with your legs.
When Ms. Boone had inquired of you as to when you might be able to go visit her, you said the end of this week or by next week. If when you go to visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are, I'm going to ask you to file a similar notice.
I would.
That information was provided to the jail.
It's
on
money.
What date and to whom. Okay. All right. Thank
Sure.
you.
Your Honor?
Yes, ma'am.
What would the hearing be for on the 14th then, for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those 2 boxes for your review outside of the laptop, we would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents. It may not be necessary. We're going to go ahead and set it. If we need it, if we don't need it, we will not have a hearing.
Thank you. And then so there would not be needing to be made an updated evidence control sheet right now. It has been tossed to Mr. Lane.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
We'll be done by 9.
No, it looks like they do.
That is the 9th now.
We're available, Your Honor.
Okay, Ms. Barrios will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay? All right. Is there anything else we need to address this morning, State?
Not from the state.
Anything else we need to address, Ms. Boone?
Please bear with me just for a moment.
Of course.
What was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
I need to research that matter a little bit further before I can make.
Are you paying attention, Sarah?
Media access.
Do you know what your deadline may be or estimated?
It'll be well before the 3rd. That deadline is set for September 3rd at 9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided. The names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robinson, Courtney Battle, and Malik Muhammad.
Thank you for that. Would you be able to provide me with a hard copy?
I will put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed to address the state directly.
Yeah, you're representing yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom and during the evidentiary, the physical evidence, that I might be able to utilize that?
Let's see how they handle this one.
She really wants a copy of
My
her
understanding
phone.
is
I want to know
there's
why.
imaging done on your phone with software called Cellrite, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person to hire. I know that defense attorneys in this area hire somebody named Richard Connor, C-O-N-N-O-R, and then that will be between you and the JAC and him, whether or not he wishes to work for you and at what rate, so on and so forth. And then that examination would be done by him, with us being present if we want to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it
The
is.
problem, you don't know how to read the Solbart report.
A legal expert that can give me a near download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list sooner than later if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all of that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
It has not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline. There is additional data there, and we will make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence. Like you said, there's so much of it would be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what, based on my experience from other phone examinations is, all that information should be there. And it's typically presented in 2 different fashions.
She's gonna claim they tampered with the phone.
A large PDF, typically hundreds or thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We are going to make sure that that is taken care of.
And that,
What
just
was
as
that date?
clarification from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you. And to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return to the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or any prior. So this would be a milestone, an epic milestone for me to be able to finally do that. So now if I don't have what I need or I'm looking for, how do I go about?
All right, we're just listening to a little conversation between opposing counsel here.
Do I need to write a motion? I don't know what I need to do in order to finally get
Can't give you legal advice, lady.
She's not listening.
With the other physical.
What was
So
that?
Again, that is going to be something that
Never mind.
requires an expert.
I was joking. I wasn't listening to you.
Get a defense expert, the JAC pays for
I was
it,
being funny.
Then we make arrangements to meet with that expert.
Uh-huh.
That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, we're going to make sure that that is provided.
Okay. that is not able to be included in the other physical evidence that you all are supplying.
No, what I'm saying is there's two different ways that I see phone extractions. One is the PDF, which is what I think you're referring to as the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program, and all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before, just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes. I am grateful for your information. Just to clarify, please, during the physical evidence and me viewing that here in the courtroom, am I not able to physically open my phone and search through it?
No, because
Okay.
it needs to be in a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of its phone.
The phone will not be turned on during the trial.
Ma'am, do you have any other questions?
Please say no. Please say nothing further.
Okay, so everyone is aware that I'm in the process of trying to talk to the captain. And handcuffs, okay. Your Honor,
Yes, ma'am.
I believe I am okay, but right now, you and I do not have a direct way of communication, and I didn't know another big hurdle is. if
3 more minutes, people.
internet access,
We're almost through this.
I don't know if emailing or messaging or whatever, however it is that you and I can communicate. Rather than snail mail, I'm writing you a letter. I don't know when I write a letter, how soon you receive it, because sometimes it's days or weeks that it is uploaded to the clerk's website. Do you have a general time frame of when you actually know of something? Because you already had my address correction, but I don't believe updated.
Well, it's been updated
No,
now.
I mean on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Do you have any other suggestions?
Nope.
If I do not have internet, would my only possibility to correspond with you be via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me.
And there's a good answer. I
review
get it
You
when I
saw
get
the
it.
motions that you made
Mhm.
reference to at our last hearing, that you had 5 of them. We set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or I'm able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadlines that we addressed this morning.
Yes, thank you. And for any, I'm not sure specifically which JA, but as soon as something is scheduled, could you all please make sure that I'm included in the certificate of service or portal or whatever it is I might be attached to in order to receive notices to be properly prepared?
Notices have been set, ma'am. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been filed with the court, including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State, anything else?
No, Your Honor.
All right, we'll see you all Friday. Thank you very much.
Thank you very much.
We'll return Ms. Boone to the custody of the Orange County Jail.
Woo, we survived. We got through that. We got through another hearing. Yoda didn't. I think Yoda's down. Yoda's dead, I think.
Down for the count.
Man, you got here for just the exciting part. The conversation amongst lawyers. Surfing Bird says, That's nonsense. An attorney continues to represent clients despite unethical requests. They merely refuse the request. And I'm saying that she is abusive and harassing and probably obnoxious. That's not grounds for letting any of the lawyers quit. The judge erred. Oh, I strongly disagree with you, sir.
As do I. There's this little thing called oh, damn it, I can never say it.
Irreconcilable
Irreconcilable differences, which is a legitimate reason for any lawyer to walk away. I myself have had decided on occasion, so no.
Yeah, your client asks you to do something illegal, unethical, immoral. You can say, no, I can't do that. If they insist and say, you are my lawyer, you are acting on my behalf, I insist you do this, and I'm not speaking to you, I'm not cooperating you, you must do this, then you have to do that. You have to, there comes that point when it's abusive.
Mm-hmm.
Well, Surfing Bird, if you were a public defender for 10 years, then you know all about the reasons and the circumstances under which a lawyer may request to be released. And if you come to us, there's such a communication breakdown where she's not talking to you. The only thing she is doing is accusing you of being incompetent, accusing you of being on the prosecution side, accusing you of these things. What do you do? There comes a point when you've had enough and there is no forward motion on this. There's a total breakdown of communication. Then it's time for someone else. Certainly you would know that. It happens quite a bit. Yeah, no, she's not the norm.
And if she was in your 10 years of service as a public defender, I tip my hat to you, but I also say, may God have mercy on your soul, because that must have been a rough 10 years. Damn.
Yeah. I suggest you go back and look at the emotions and the hearings wherein first of all, she fired some of them. And she requested that some be removed, and others, I think 3 of the 8 were the ones that were saying, look, I need out of this. There's no way this is going ahead. I can no longer work with this person. So she's responsible for most of them going. There was a couple of conflicts where like the first lawyer conflicted out. I think there was another conflict. I think 4 of them she got rid of, and the other 3, I think, asked to be released.
It's a hell of a record, though, isn't it?
Yeah. So anyway, there's the deal. All right. That's I think that's kind of the end here. It's another 3-hour, 2-hour stream. And if the court erred, she can always bring it up on appeal. So there you go. If she can find a lawyer that'll help with the appeal. Let's find out who is doing what live so we know where to send you all. YouTube studio. We'll go to the studio here. And during this little break here, I'm just reminding everyone to please get down there and hit that like button, and please hit the subscribe button. It is right there waiting for you to tickle it, waiting for you to touch it and odd number of times. Touch it oddly.
You don't have to be creepy about it. Just smack it like it's a hot woman's ass, people. You can do it.
Touch it oddly. Not a number of times. Hit that like button, hit the subscribe button. And if you are subscribed, always double check to make sure you're still subscribed. And while you're at it, make sure you pop on over to Ozzy Overlord and make sure you subscribe to him as well. Because, hey,
just today managed to blow through an entire 2.5-day trial. We'd spent 3 hours going over the Wisconsin v. Kemen-Sema trial. The 6-foot guy that decided to punch someone in the head caused him to fall on the ground, and it was all over tattoos, which was real classy. But yeah, we got the whole way through it. So,
well, there you go. If you're going to punch someone in the head, it should be for a good reason. One that's not going to get you sent to prison for the rest of his life, I guess.
Still, he's going to be sentenced in September, but yeah, felony manslaughter because he basically alleged that he walked out and 2 guys were holding bar stools up and were going to attack him. So he was claiming self-defense. Kind of hard to do that when there's video footage showing you chasing someone out of the bar and then hitting them.
Yeah, that sounds like that would be difficult. That would be a small sticking point in the defense, I guess. But I think we're going to send you on over to Cat Not Williams for day 106 of the YSL Young Thug trial. Motions, evidence, and what to do. That's where we're going to send you on over there until tomorrow. Oh, trust me, we can't send you to Emily Baker. That she is firewalled off from the entire rest of the internet. Yeah, she, at least me. And if it's not Emily D. Baker, I'm the only other person on the internet you should be watching, other than Ozzy Overlord, of course. We're the only three you should be watching. Just saying. All right, folks. We are going to head on over there tomorrow. I don't know about tomorrow. Tomorrow there's a couple things we can do tomorrow, and I haven't made a decision yet. We can either go ahead with part 2 of the 58-page love letter to the judge, or we might want to take a look at the newly nominated vice presidential candidate for Kamala Harris, the governor of Minnesota. Might want to take a look at that. I'm not sure what we're going to do. Just stay tuned. And if you do sign up, hit that subscribe button and the bell notification. You'll find out what I'm doing. And Law News and Laughter with Ozzy Overlord is the other channel you want to make sure you get to. What are you doing tomorrow?
Tomorrow I'm going to be looking at...
Tomorrow for us, evening time for the people in the U.S.
Fair. I will be doing my recap of the Wyambella police shooting that was in Queensland. That has been going to inquests basically for... I think we're in the 2nd or 3rd week now, so I need to do a recap of that. That was 3 alleged SOV sits here in Australia with ties to people in the US who allegedly coerced a few police officers to attend the property, saying that there was a missing persons report, and they gunned down 2 police officers and a neighbor. So they're looking into exactly how that all panned out, what the ties were, and how to fix it going forward. I don't really think you can fix that one because I feel like they were maybe just a special kind of crazy, but we're going to be looking at that. So that'll be interesting.
All right. Don't miss it. Until then, let's go head on over to Cat Not Williams for day, 183,000 of the Young Thug trial. Let her know that Ozzy Overlord and Legal Vices sent you. Take care, people. We will see you tomorrow, where I will be talking about something. Bye. Mods, thank you so much for being super awesome and super moddy. You guys rock. Thank you so much for the support today and the unlocking of the achievements. Thank you so much for the super chats, the monthly membership chats, and all those other fun things. And thank you for just being part of the conversation. Thank you for keeping each other company and for enjoying this with all of us. Chat, you are the best chat. The Vice Squad chat rules. See y'all. Bye now.